Now, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Oh my law, here we go. How is everybody? Hello, Justice Jayne. Hello, B Rabbit. Hello, Angelic. Cat. Hi, Tammie on replay. You're listening on replay. Hey, Jude. I've dedicated over a decade of my life to investigating innocence fraud campaigns and what is a tsunami of fraud sweeping our justice system. What makes the Karen Read case unique is that there is an innocence fraud campaign that's being done pre-trial based on campaigns that are done post-litigation, post-trial, post-conviction, and with the convicted murderer safely behind bars. Even the campaign slogan, Free Karen Read, suggests that Karen Read has been tried, convicted, and sentenced, and that Read is residing behind the cold steel bars of prison instead of the reality. As the Free Karen Read campaign is in full swing, Karen Read is laying her perfectly coiffed hair down on the fluffy pillows of the Omni Hotel and occasionally swinging into the bar of Smith and Wolinski's for cocktails with the star of her team of lying lawyers, the ethically challenged and morally deficient Alan Jackson. Innocence fraud is simple. A fraud of any kind is making something look like something it's not. A financial fraud aims to make a Ponzi scheme look like a dynamite investment opportunity. And an innocent fraud campaign aims to sell a guilty person to the public as an innocent victim of our criminal justice system run amok. The concept is simple, but the actual techniques used by innocence fraud campaigns and innocence fraudsters are not quite so simple. Today, I'm going to talk about the language used by lawyers on both sides of the aisle. In particular, I'm going to talk about Hank Brennan and his carefully crafted language in Tuesday's pretrial hearing, a crafting of language that was so clever, it could be called a lingular sleight of hand, or a linguistic sleight of hand, maybe even better. When Hank Brennan said in the very same hearing, we, meaning the Commonwealth, cannot fight fire with fire, that can only be looked at as an admission in the negative. I'm proposing that is exactly what he was doing, fighting fire with fire. I'm also going to talk about editing and presentation and how carefully crafted language, editing, and presentation can give the appearance that you have just watched an interview when it was a hearing, when it was a clip from a Zoom pretrial hearing. So let us get into it. So much was made in yesterday's hearing about Hank Brennan lying and referring to a court TV interview done with Yannetti and Karen Reed. Now, I'm going to share my screen because I thought this was a good discussion of it here with Kate Peter and Joe Flipperhead. So Kate Peter, of course, is Masshole Mafia. So Joe Flipperhead says, Hank Brennan, another fumble. Today in court, Hank Brennan accused David Yannetti of going on court TV to talk about DA Michael Morrissey being under a federal investigation. This is a lie. Yannetti didn't, quote, go on court TV. This was a Zoom hearing in front of a judge. Okay. And as in response, Masshole Mafia, Kate Peter says, wrong again, bucko, here it is. You're half right, though, in that sense that Yannetti did tell this same lie to the court during a hearing as well. Thanks for pointing that out. And then she corrects herself and says, well, gotta correct myself. I've reread Court TV did use the Zoom footage in their segment. There was a separate in-person hearing incident of this same lie as well. Okay. But let's get to the actual hearing and listen to what Hank Brennan actually said.
Hear you on the conditions.
Thank you. As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule of Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion, there was recently provided materials that the court ordered the defense not to disclose to the public. Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, given the history of this case.
So if you don't know what this protective order is about, they put in a letter from or a communication from Proctor in one of their filings where he says he couldn't even watch the closing arguments. And all those communications are protected from Proctor's cell phone.
It is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial. There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness who was not bound by a sequestration order at the time of closing, didn't want to watch a closing, there was no good faith basis whatsoever that that witness watched other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information of the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of...
Right, because they can't litigate the facts. But listen to his language, a carefully crafted campaign. Lawyers do not choose their language just randomly. It is very, very carefully chosen, and Hank Brennan is really the master of this. So what I'm talking about today, at least in the first part of this episode, and then I'm going to talk about why I call this episode The Wrecking Ball. I'll get to it, guys. Is in the same way that we saw Alan Jackson get up in front of the court at Karen Reed's trial and say to Daniel Wolf, "You've never met me before." Now that may be, we don't know if they had any personal meetings. As far as the evidence, and it's really just a skeleton collection of evidence, in my opinion, that we've seen as far as communications between ARCA and the defense. They had never met. You've never seen me before. I've never seen you before, but I've talked to you before on, right? You've never seen me before. You've never seen my client before. We've never talked before. You weren't paid, and it goes without saying you were paid by us. They hadn't been paid yet. But there was a retainer. They were being paid. And that was the argument Alessi made. It wasn't dishonest because they hadn't been paid yet. So to make it look like they weren't ever getting paid, that they were independent, unbiased witnesses who would never take money for their testimony. Instead, Alessi's going to argue, oh no, it's just that he was just saying that they hadn't been paid yet. They weren't trying to pull the wool over the eyes of the court or the public like they did for months and months and months, pre-trial, post-trial. And after that and after the hearing where it all got exposed, where Alan Jackson was asked, did you pay for their testimony? No. What did he say? Never or not? What was the exact phrase? I can't remember. So I'm paraphrasing. No, never. Something like that. I can't remember exactly.
Jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court. It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors. And so not only is there really not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We did turn it over as a text message, and notice of discovery 51, a protective order was issued, docket 416. We produced it, notice of discovery 57. And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now,
So I consider the history. So now he's talking about the history of how this campaign has operated. And when we're talking about the court TV episode, that used a clip of that hearing. It was the defense fighting against sanctions and fighting against any kind of protective orders in this case. So they wanted all the information out as possible so they could present it in the way that they wanted to, and poison the jury pool.
After they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online. And it seems that was the very purpose it was spit out into the community. And so the Commonwealth position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements. And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's...
So what is Rule 3.6? Now, 3.6, and the link is in your description. It's also in Innocence Fraud Watch's blog, which I'm going to get to in a minute. It has to do with trial publicity. This is from the American Bar Association. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make any extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjunctive proceeding in the matter. Notwithstanding, paragraph, a lawyer may state the claim, offense, or defense involved, and except when prohibited by law, the identity of the persons involved. Information contained in a public record. So a lot of loopholes here. Information that an investigation of a matters is in progress, the scheduling or result of any step in litigation. Oh, wait. Notwithstanding, a lawyer may state, okay, the scheduling or result of any step in litigation, a request for assistance in obtaining evidence and information necessary thereto, a warning of danger concerning the behavior of a person involved where there is a reason to believe there exists the likelihood of substantial harm to an individual or to the public interest, and in a criminal case, in addition to subparagraphs 1 through 6, the identity, residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in the apprehension of that person, the fact, time, and place of arrest, etc. A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. But there was little publicity. Most of the publicity was created by Karen Read herself. There was some publicity after John O'Keefe's funeral, but nothing to the level of what Karen Read has done with her innocence fraud campaign.
Participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, the defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The government has, the defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Marcie is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Read matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on Court TV with Miss Read.
Okay, so yes, he did appear on, listen to the language there. He appeared on Court TV with Miss Read. Let's look now at Joe Flipperhead's tweet. Look, see, this is what fraud does, and I'm saying that Hank Brennan is fighting fire with fire here. So let's show his tweet. So Joe Flipperhead says that he said he went going on Court TV. Hank Brennan never said that. Here's David Yannetti and Karen Read edited together from a Zoom call. This is not what the Zoom call looked like. I'll show you in a second. They did appear on court TV. Their Zoom hearing did appear on court TV. That is factually true. But it makes it seem like, and court TV certainly added to this when they called the episode. What is it exactly? Let me get to it. Karen Reed's attorney talks federal investigation with court TV. Now, at the end of it, there's a clip of Alan Jackson, and it looks like he's in his home wearing earbuds. Hard to tell where that interview came from without being, unfortunately, I'm not a Karen Reed case, what do you call it? Rain Man. I don't have a file in my head of all the interviews Alan Jackson has given, where he's given them, and was this from somewhere else? But I just want to show you the difference between how court TV, what the actual hearing looked like. So this is what the actual hearing looked like. Okay. And this is how court TV edited it. Does everybody see that? To make it look like, almost like they're talking right to you, the viewer, giving an interview. Very different than when you see the court, you see Judge Ganoni, right? That looks like a hearing. This makes it look like an interview, doesn't it? So this is a linguistic sleight of hand here to aid to his argument. But we've seen, if you saw the beginning, Karen Reed has not shied away, and her lawyers, from giving interviews on the courthouse steps to Ted Daniel, to Vanity Fair, Julie Miller. It has been a campaign. So am I particularly bothered by Hank Brennan? The essence of this, of his argument, is he's saying that the Commonwealth's hands are tied in order to give Karen Reed a fair trial. But Karen Reed doesn't want a fair trial because she can't win in a fair trial. In a fair trial, the facts are against her. With an innocence fraud campaign on her side and the poisoning of the jury, she has got the cards stacked in her favor. So this is something that was pointed out in Innocence Fraud Watch's blog, inspired this episode. January 17, 2024, David Unetti stated, the Norfolk's DA's office and Karen Reed's defense team participated in a conference call yesterday with a representative from the U.S. Attorney's Office. The U.S. Attorney confirmed during that conference call, again, do you see the repetition? For both parties. Does everybody get that it was confirmed? The U.S. Attorney confirmed during that conference call, confirmed for both parties that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth. January 18th, 2024. Hank Brennan stated during his March 4th hearing, there has been an ongoing promotion to talk about ARCA. and federal witnesses and what opinions are, which aren't in line with reality. The reports or the testimony, it is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case and was provided in the collateral case was again sent out to the public domain. The government has, the defense has not only trampled over 3.6, they've alluded to continually about matters that have no basis in fact. January 18th, 2024, District Attorney Marcie is well aware he's a target of a federal investigation. We're aware of the hearing in Norfolk County Superior Court in the Karen Reed matter. In connection to this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office. After they implied, that was made by Mr. Unetti, and I have the clip of it. He also appeared on court TV with Miss Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Marcie and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. David and Unetti did not appear on the court TV show per se, but some people, like Kevin Lenahan from Yellow Cottage Tales, have wrongly interpreted what Hank Brennan actually stated. So let's take a listen to Kevin Lenahan's interpretation of it.
Yesterday, Mr. Brennan represented to this court that I had made an extrajudicial statement regarding Mr. Marcie and the federal investigation. You'll recall that I stood up in rebuttal and said that it was in court advocating for my client. He then said court TV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a court TV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Unetti is referring to that comment that was in the court file. And so I intend on remedying that record. There was also.
He intends on remedying the record. But listen to what Hank Brennan says here. Unfortunately, Kevin sighs over an important part.
A conversation.
Or when Hank Brennan's talking. I don't know how important it is. Excuse me. I'll remedy my record. Manny says, can you please make a song about being a cat expert witness? Okay. I am a cat expert witness. No payment yet. Nobody wants to pay me $600 an hour to opine on cat care. I'm shocked. And one that belittles the fake dog expert lady. Yeah, Marie Russell does need a song. She's so, I don't know how they can testify with the victim's family there, especially Peggy O'Keefe with her tissue in hand, never far from her fist, cries most hearings. I mean, how do you live with yourself knowing that you did this for money, for the attention, for your own narcissistic ego? I mean, I guess, your own narcissism and ego. I don't know how they live with themselves. You know how I don't know how they sleep at night except on a pillow full of money, blood money.
All right, so provide it to Mr. Unetti. Mr. Unetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that I made this extrajudicial statement. I said.
No, Hank Brennan never said it was an extrajudicial statement. He was running through a pattern of accusing the district attorney of being under an investigation for his treatment of Karen Reed. Now, there was an investigation started by David Yannetti and Karen Reed, federal investigation, but it came up with nothing. And he certainly, everyone who got Karen Reed was the target, but it wasn't, particular, because Michael Morrissey was so dirty that he was the subject of an investigation. And I think that Hank Brennan will argue that that was his point. Not that he appeared with Ms. Reed on court TV. Did you get it? Just like if court TV played a clip of this, I would have appeared on court TV. Never mind. It would make it seem like I was a guest, but I didn't have to be. If they used this clip, I would have appeared on court TV. I did. I appeared on court TV. They're wordsmiths, these lawyers.
Specifically, I did not. He contradicted me in that.
And David Yannetti knows the word game, and now he's going to make it look like, because both of them know it's untrue, that they gave some interview to court TV about this subject. They're both are playing the game. Do you get it? Now Hank Brennan's going to move away and said, no, this is you're just misinterpreting my words. Listen back to what I really said. I was talking about a campaign that targets witnesses, that targets out specific people and violates Rule 316. You're talking about me making statements to court TV. I never said that. It's a little game going on here. Let's see how Kevin takes it.
That's where we left it, and he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, where I was arguing before Your Honor.
As much as I think Brennan steamrolled today, was incredibly effective, brilliant. But I did, what Yannetti just said there, I thought the same thing yesterday. I remember hearing it thinking, I don't think that was court TV. I think that was in court. So that's now two pretty big blunders.
It's not a blunder. I would argue, I don't know, let's talk about it. I would argue it's not a blunder. It's fighting fire with fire, something he says he can't do in court as the Commonwealth. He's fighting fire with fire just a little bit. He knew that this, thank you, Angela Wittick, says if you missed her comment, Hank knew this would light a fire. Did. He knew. He's like, okay, you're gonna play games with the ARCA semantics. He's referring to a campaign of, long campaign that has been done to poison the jury pool. And even before that, I think it was really the campaign was to get the charges dropped before they ever go to trial, which is something that Yannetti that's his expertise, getting charges dropped before they go to trial. And Karen Reed, will never take a plea deal in this case. She'll never admit any guilt. And this campaign will never be over. If you think it will be over, should she get convicted of anything, even the smallest charge in this case, you are so wrong. She feels done for just to be charged. And I think we're going to also see if, say she gets acquitted, or if she gets charged and if she gets convicted and the sentence is overturned, In appeal, we're going to see what innocence fraud is all about, which is the post-litigation civil cases. And that's where these lawyers make the multi-million-dollar payouts. And Karen Reed wants some of that multi-million-dollar payouts you get for wrongful convictions. It is an absolute tsunami of those civil cases. Our civil courts are so abused in America.
They just blunders. They're not intentional in the last few weeks on this. And so he needs to get someone to help him a little bit with the research here to make sure.
Oh, no. Laura McLaughlin knows this case. I would argue I just have a little difference to Kevin on this view. Inside and out. Did you hear her yesterday? She got that date, stood up and gave it right away. She knows this. Adam Lally knows this case inside and out. This was not a blunder. This was a linguistic sleight of hand.
If you're going to quote somebody else, that it's accurate. You know, they're obviously blunders. They're not intentional, but they're big and they shouldn't happen. And now there's been two of them.
Yeah, I don't think that that's a blunder. But pretty certainly got the Karen Reed people talking because they don't really have much now. And Hank Brennan has, in the past hearings, done what the Commonwealth has done. He's spoken to the public in his hearings as well as the judge and say, look, we're up against it. Look how this has gone. Let me expose the fraud. Let me expose the fraud with ARCA. Here it is. Here's the communication with ARCA. Remember what he says? That's not trial by ambush. That's getting duped. That, my friends, is the wrecking ball. And it has come into this case to my extreme delight when it looked like Karen Reed had the world on a string sitting on a rainbow. Here she was riding around with Ted Daniel, flaunting her stays at the Omni Hotel, her drinks at Smith & Wolinski, doing more illegal raffles with the press all supporting her. And when the ARCA fraud got exposed, because that is really the crown jewel of the defense. And I hate to call it the crown jewel because it's more like a shiny object in a bottom of a garbage can that is the defense in this case. But that's the best thing they had was the ARCA witnesses. And to say they were independent, once you know they were paid, once you know that they crafted their testimony with the defense, script wrote their testimony with the defense. It's a better way to put it. It's all over. What do you have? You have Lucky Loughran. You have McNasty Green. I mean, guy who's been arrested. They had to rewrite the entire Cellbrite program for his error. And then you have Marie attention-seeking Russell. Has gotten fired from her jobs, hasn't worked in years, is a true crime fan who reads about the case in the paper and wants a little bit of attention for herself. And those witnesses should never be allowed to testify in this case. But if you listen, the reason I played the whole clip is because Hank Brennan wasn't just talking about the federal investigation. he's talking in the 3.6 violation. He's talking about all the things that the judge has turned her head and looked the other way and permitted in her courtroom, and allowed this trial to become a circus, from having just allowing the Karen Reed protesters very close to the courthouse, in my opinion, to not putting a gag order on the case, to allowing raffles. Karen, I'm glad she allowed Karen Reed's interviews, because I believe they're all coming in and they're all going to be very damaging for Karen Reed. But let's look at a little bit at that hearing, shall we? So I just thought it was curious. And then I'll show you how Court TV kind of spun the information and went with it and sold it. And Court TV was also part of selling this fraud to the public.
Those letters hidden from the public is warranted. The court must first consider the content of those letters. And in order for me to be able to argue against this motion for a protective order, I must...
So just so it's clear, I have not seen those letters.
Okay. I still, Your Honor, I must discuss the content.
So the Commonwealth wants a protective order, and he's got to argue and talk about the content of it. He wants more information out there.
Of those letters to some degree, and argue to this court why a protective order makes no sense in this case. And with your permission, I'd like to divide my argument on this issue into two parts. First, I will argue to the court that the Commonwealth has not met the legal standard necessary for the issuance of a protective order. And second, I will argue to the court that a protective order will accomplish nothing in this case, because the content...
All right, so which part do you need to reference the letters? Because I'm going to need to read them before you reference them.
So with regard to the first part, which is that the Commonwealth has not met the legal standard, the only way to discuss whether they've met the legal standard is to know what the letters are. And just
right. So I need them. I don't have them, and so you would be arguing the content of the letters in the first part. All right. How about the second part of your argument? Would you be arguing them as well? Nobody provided them to me.
Well, this is the Commonwealth's motion, Your Honor.
Yeah, and your opposition, and I don't have from anyone.
Right. So they're going to blame it on the Commonwealth. No one has the letters. Oh. It's the Commonwealth's fault. Fault, excuse me. Commonwealth's fault. Well, you're arguing against it. You should have them too. Never mind. Let's look at Vinnie Politan selling this nonsense to the public, shall we? They call it Karen Reed's attorney. So we know what they argued as far as the federal investigation, because I've read it. Let's just look at this Court TV, a little bit of this Court TV episode.
John did. From that point forward, there are two very different versions of what happened. Prosecutors say Karen was mad at John and purposely struck him with her car and left him on the ground to die in the snow. But Karen and her defense team say John went to the party. Something terrible happened inside the house, and his body was placed outside, where he was found dead the next morning. Karen has been charged with murder, but claims she is the victim of a big cover-up by police. Prosecutors...
Do you get how Karen now is Karen? We can call her Karen. We're on a first-name basis with her. This is something that innocence fraud campaigns often do. They also use pictures of Karen Reed as like Karen Reed or whoever else they are running the innocence fraud campaign for, childhood pictures of them as a little baby, especially if they're on death row. Say, you can't kill this innocent child. Never mind the person, the convicted killer, the convicted killer is in their 50s, 60s, 70s, 40s. They'll use childhood pictures. Anything to invoke sympathy and familiarity, and it could be you. So anything to put yourself in the place of the convict or the accused, and to distance yourself from the victim and the victim's family and the prosecutors. But prosecutors say, it doesn't say Adam says. Adam says.
Insist Karen Reed is a murderer, while she insists it was someone inside the house that night who was responsible for what happened to her boyfriend, John O'Keefe. And now another twist, a federal investigation into the way police handled this case. Tonight, we look at that federal investigation of the investigators and how it will impact this upcoming murder trial. And we'll look at the crucial piece of evidence that Karen Reed's supporters say proves her innocence as we investigate the death of Boston police officer John O'Keefe.
Isn't it curious that we really haven't seen those? Look at those printed signs. As someone who's raised by activist parents, I know that, do you see that do you see that right there? Look at these signs, all printed up. So many of them. You use signs as an activist, someone who's, as I can say, someone who's been dragged as a child to so many protests, to make it look like it's a bigger crowd. And there's been rumors, I don't know if they're true or not, that she hired crowds in the beginning.
Proves her innocence as we investigate the death of Boston police officer John O'Keefe. I'm Vinnie Politan. Thank you so much for joining us tonight. This story, unlike any we have covered in many, many years. I want to start tonight, though, talking about a case that we didn't cover here on Court TV because it happened back in the 1920s. The case of Sacco and Vanzetti, two guys who claimed that we were framed for murder.
That's one of the oldest innocence fraud campaigns, and children in schools all over America are still being taught that they were framed for anti-immigrant sentiment, when my view on the case, and many other people who have dove deeply into it, believe they were guilty. They were convicted, and this was all started because of a book called Boston. I'm going to take a break so I can pull up what I need to pull up on that. Hold on one second. Let me take a quick break. I'll be back. Don't go anywhere. Be back in 1 minute.
Glass of wine. Roberta will be back in no time. This podcast is listener supported, so smash that like button and subscribe, or become a patron for exclusive content if you are so inclined. Have something to say? Shoot Roberta a super chat. She will do her best to read it on air without delay. Now Roberta's back and ready to put the true back in true crime. Here's Roberta.
Okay. That actually took me a little bit quicker than I thought to find what I needed. But here is the book by Upton Sinclair, Boston, where he embedded himself with the defense of Sacco and Vanzetti's defense. And this is where the Innocence fraud campaign started, with this book. So this is what started it, and this is created the American myth about Sacco and Vanzetti that lives on to this day. If you've read The People's History of the United States, talks about it in there. But little interesting article from NPR, hardly a usually ideologically aligned with innocence fraud campaigns. Sacco and Vanzetti, guilty after all. Anarchists Nicola Sacco and Bartolomeo Vanzetti were a cause célèbre of the 1920s, convicted of murder and executed after a trial many felt was a farce. Author Upton Sinclair wrote extensively about the case. Newly discovered letters reveal his suspicions. I don't think they were suspicions that the men were guilty. Debbie Elliott gets the details from Upton Sinclair's biographer, Tony Arthur. A California man, hold on one sec, browsing through boxes at an auction unearthed a fascinating discovery, a dusty letter dated 1929 from famed muckraker Upton Sinclair, who also wrote The Jungle. Sinclair just had published a novel called Boston about the murder trial of anarchists Nicola Sacco and Bartolomeo Vanzetti. Sacco and Vanzetti were a cause célèbre during the 1920s. Left-leaning intellectuals, including Sinclair, championed their innocence. Their eventual execution in 1927 touched off riots in Paris and London. Upton Sinclair's letter reveals he knew more than he let on about the case. We're invited Upton Sinclair's biographer, Anthony Arthur, to tell us all about it. He says it's nice to be there. So in this letter, Sinclair describes a meeting with Fred Moore, who was Sacco and Vanzetti's lawyer at the time. They're meeting at a hotel in Denver, and he writes, quote, "Alone in a hotel room with Fred, I begged him to tell me the truth. He told me that the men were guilty, and he told me in every detail how he had framed a set of alibis for them." So what does this tell you about Sinclair knew about this case, and that what was different from what he wrote in the book? And his biographer, Mr. Arthur, says, well, it tells you that he had confirmed by an independent source who was involved in the case. I don't know how independent his own lawyer is. His own lawyer. I wouldn't call that an independent source. His own lawyer said these guys are guilty as heck. Who was involved in the case, that the doubts that he had come to have himself, I don't think those are doubts. He was writing a novel about two men who were charged with a crime. He was certain of their innocence when he went into it. He became doubtful of his innocence as he went along, and according to this, he became convinced of their guilt by the conclusion. And then, so just to cut this short, because this isn't an episode about Sacco and Vanzetti, he ends up writing that I have to write a book about innocence because that's what the public demands. That's where the do-re-mi is. And that's the acorn that grew the great oak that is I would say cemented bigger than a great oak. That is the American myth of Sacco and Vanzetti. And so here we have Karen Reed, over 100 years later, in being tried in the same courthouse as Sacco and Vanzetti. And Vinnie Politan is going to use the Sacco and Vanzetti innocence fraud campaign myth and apply it to Karen Reed here.
These two guys were accused of an armed robbery turned into a murder. They were tried in the courtroom. They were literally put in cages as the evidence was presented. But from the beginning, they claimed they were innocent and they were being framed for what happened. You see, they were very unpopular because of their political beliefs. And in the end, they were convicted. They were executed. But 50 years after...
Right. So he's going to repeat the myth that in many innocence fraud campaigns do this. Almost all of them do. So they attach it to some kind of cause. So this is anti-immigrant sentiment. With Karen Reed, it's anti-police sentiment. It's a little different, but they're going to say, so there has to be a reason why they were convicted and why all the appeals failed. It's because they didn't like their politics. They didn't anti-anarchist sentiment, anti-immigrant sentiment. Funny Bunny says, Dean Walker, thanks so much. So nice to see you, Dean. Hope the grandbaby is doing well. Funny Bunny says, Roberta, let's intertwine trials. Say Donna Adelson, say in your Donna Adelson voice, me and my team of let's see. It's hard to do because I have Karen Reed doing it. Me and my team have marshaled every resource. There you go. There's Donna for you, Funny. Every resource to get to the truth of this matter. Just my hysterical Donna voice.
That execution, the governor of Massachusetts made a proclamation.
And also because the country is deeply divided about the death penalty. And there's so much money with anti-death penalty campaigns. This has lived on because the anti-death penalty people need to show that we have executed innocent people. And this is a thing that gets repeated over and over again, where they take an old case, they show an old case as, see, we've really executed people who were totally innocent of committing the crime. Which I don't know why they can't just, win that argument on its own merits. But
saying these two were tried unfairly. They didn't get a fair shake inside of the courtroom where they were tried, and proclaimed them innocent men. Sacco and Vanzetti, an extremely famous and notorious case that divided the public. That trial was in Dedham, Massachusetts. Now, in the same courthouse, in the same courtroom, Karen Reed is saying, I was framed. And this case, too, dividing the community in Massachusetts. And now that this thing has struck with people across the country through podcasts, through this program, through what has happened inside and outside of that courtroom, and the bloggers and everyone else involved in this, has divided the community around the country as to what really happened in this case. Now, when a criminal defendant claims that I was framed, you know me, I'm a former prosecutor. That's the filter that I analyze everything through. I take it with a huge grain of...
No, he doesn't. What a disingenuous douche this guy is. No, you don't. No, you don't. No, you don't. And now he says he thinks that she's guilty of something, just not the second-degree charge. Boy, the wrecking ball turned him, changed his opinion right around.
Salt. But this case is a little different. There's something else going on here, literally going on. The FBI and the Department of Justice is investigating the investigators.
Which is the whole reason why you start an FBI investigation, to just as fraud always is, to make it look like something's going on when it's not. Make it look fishy. Make it look like there's something corrupt and rotten under the surface. Because why else? I mean, why? Because no one likes Karen Read? They want to frame her? No, it's because of the thin blue line, guys. The blue wall of silence.
While this case is still pending, there's an investigation on how this case was handled by police. And the entire case for the defense is that the police didn't handle this case. Police took evidence, moved it around, and framed and then covered up what really happened. Framed Karen Read and then covered up the truth in all of this. That's what they're alleging. So in this case, there will be a search for the truth inside that courthouse in Dedham, Massachusetts, where Sacco and Vanzetti were tried, and now where Karen Read will be tried. But it'll be a search for the truth not only of what happened to Boston officer John O'Keefe, but also a search for the truth of how this case was handled by the investigators. And today, another big hearing, and we heard something that I think for the first time, like we heard little bits and pieces about this federal investigation, but I want you to take a listen to David Yannetti, who is, you'll hear his voice. He wasn't in the courtroom, but was appearing via Zoom in this hearing in the Karen Read case, and gave the world, the judge and the rest of the world, an update on that federal investigation of the investigators. Take a listen.
On that score.
So just before we get into Yannetti, I just want to note that isn't it interesting that Vinnie Politan on Court TV knows that when David Yannetti advocates for his client on a publicly aired hearing, that he's not just informing the court, that he's not just advocating for his client, he's also informing the world. Isn't that curious? David Yannetti seems to only think that it's just advocacy for his client, that he's not, say, spreading his misinformation to the public. It's just advocacy. So curious that Vinnie Politan seems to know that the advocacy isn't only for his client in court, it's also for the court of public opinion.
Something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Read defense team participated in a conference call yesterday with a representative from the U.S. Attorney's Office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth.
The investigation is taking place now. As Karen Read is getting ready for trial on these murder charges, the feds are taking a look at the people who investigated the case and gathered the evidence that will be used against Karen Read. This doesn't happen, folks. This is extremely unusual. Let's bring in Court TV crime and justice correspondent Matt Johnson, who is out.
So there's Vinnie Politan doubling down on the unusual going-ons with this federal investigation. This doesn't happen that there's a federal investigation. Well, if you know David Yannetti and you have the Read name, it's not unusual for those guys. They can get it done, right? It doesn't seem hard for them to have done. Get a federal investigation and make it look like something nefarious is going on. Wow. And just like Sacco and Vanzetti, lawyer cooked up some alibis for them. Fortunately, Yannetti, Jackson et al. Haven't been clever enough to cook up some alibis for Karen Read, but they sure did cook up a federal investigation. And they did get to cook up this idea of independent, unbiased ARCA expert witnesses. The pattern goes on and on and on and on and on, right? Defense lawyers acting in ways that are beyond the bounds of their profession.
Outside the Norfolk County Superior Courthouse in Dedham, Massachusetts, not covering Sacco and Vanzetti, but covering the Karen Reed case tonight. And this, when I heard this, Matt, I was like, this investigation is ongoing. How did this play inside the courtroom today relative to some of the things that they were arguing about?
Vinny, good evening to you. You could hear a pin drop in that Dedham, Massachusetts courtroom behind me. I mean, this is something that you've heard rumblings of, but when Yannetti actually said that there is an investigation that was confirmed yesterday during a phone call with the DA's office and also the U.S. Attorney's Office, well, it was just a complete bombshell in that room when he said also that it's ongoing. And at this point in time of the hearing, we were talking about the letters that the defense once released, communication between the DA's office, the U.S. Attorney's Office, and the DOJ. Here's a little bit more about that.
Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Marcie, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court date. And I ask this court to consider what that hearing will look like. That hearing will prominently feature the contents of all of the 8 letters that are at issue here today. The specific content of those letters is one of the grounds that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters. And I assume that that is the reason that our motion for sanctions is currently impounded by this court as well. But it is clear from those letters that District Attorney Marcie is well aware that he's the target of a federal investigation as a result of his conduct in this case. Those letters prove that he knew that, even before the U.S. Attorney ever confirmed that there even was an investigation.
And those motions for sanctions and for the removal of the Norfolk County District Attorney's Office, that's going to be discussed.
Let's just read one more time what the next day Mr. Morrissey said. District Attorney, after Yannetti said, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of the hearing in Norfolk County Superior Court in the Karen Reed matter. In connection to this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied. That was made by Mr. Yannetti, okay? Did you get what I'm saying? It was never implied that who was the target of any investigation. But boy, and it means that they can't try this case. And again, you can see that this was an effort to get this case dropped before it ever went to trial. So I'm just going to keep it short for today. The wrecking ball has come. The Innocence fraud has been exposed. Hank Brennan, I feel, is holding a lot of things that we haven't seen, haven't heard about for court close to his vest. And ARCA is the first of a bunch of jaw-dropping surprises. So stay tuned. The Karen Reed campaign is now on the back foot. And it's really been reduced to vague allegations of calling Hank Brennan a liar and a mob lawyer, and no, you do it too, and no, they lied. I don't think it's going to stick. I don't think that. I mean, if they're going to base this on Hank Brennan, correcting himself when he said what he believed, that he got this information from the feds when it came from the defense concerning the ARCA witnesses, and the rest of Alessi's, what I'd call Alessi's fantasies, if they want to base a Brennan hate campaign, if they want to go forward that, good luck. Also, as I mentioned before, Aiden Turtleboy Carney has gotten another witness harassment charge. We have not seen him in court since Hank Brennan publicly talked about the, quote, symbiotic relationship between Aiden Turtleboy Carney and Karen Reed in court. Has he been told to stay away? I would think so. Is Karen Reed distancing herself from Aiden Turtleboy Carney as today? Hank Brennan asks for the evidence in Aiden Carney's case for communications between Karen Reed and Aiden Carney. This case is heating up. To be continued. We'll talk more about it. I think it's today, Thursday. I'm off tomorrow. I'll be back Saturday if I have the right date. I hope I'm on the right date. I'll be back Saturday to talk all about it at 6 p.m. Eastern. That's the time I'm on every day, but usually Mondays and Fridays. Please share this episode. Follow me on X. Support me on Patreon. Buy me a coffee. My Karen Reed is Guilty t-shirts are below this episode on YouTube. And I'll have more of those. I have some ideas. More of those coming soon. And I'll see you all Saturday at 6 p.m. Have a great night, everybody.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. Hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my son.